So, good evening, everyone, and welcome to the fifth ASHA lecture series. I'll say two things about ASHA, and then we can begin. Then I will introduce Dr. Srikumar, and then we can begin the lecture. So, ASHA is a not-for-profit organization which stands for Accept, Support, Help Another. We work on the understanding that professional stress is universal in doctors, in most people, but especially in doctors. And we believe that doctors are perhaps not as good at helping themselves as they are in helping their patients. So ASHA was founded to increase the medical narrative about professional stress. And we do that through various means. One of these is through this lecture. The other is we have a website where information is available. We have a YouTube channel where recordings of these videos and lectures are available. We have a Facebook presence. We have a WhatsApp presence. And we have other plans for the coming year as well. Now, one of the major sources of professional stress for doctors today is when they're faced with a legal issue, when they have a complaint made against them, or when they're faced with other legal issues, even being attacked. Now, this evening, we have somebody who's an expert in helping us to understand and to deal with these. So the speaker we have for today is from our own member, Dr. Srikumar Vasudevan. Dr. Srikumar is an ENT surgeon. He is also a medical ethics teacher. He has a keen interest in medical ethics as well as in the training of people under medical ethics. So he's a guest faculty and he takes classes on bioethics at the Courtroom University of Science and Technology. He's a chairperson of the Institutional Ethics Committee at the Malabar Cancer Center. He's a master trainer in healthcare communication. He was president of the IMA in Kerala. He's currently the secretary of the National Professional Protection Scheme of the IMA. Notably, Dr. Srikumar is also chairs the Doctor Support Committee in the IMA, and he's been responsible instrumental in setting up doctor support cells, which he will speak about today. So I have great pleasure in welcoming you, Dr. Srikumar, and over to you.
Thank you, sir. Good evening, all. I think I'll straight go to sharing the screen. I'll go to the topic itself straight. Can you see my screen?
Just beginning to. Yes, we can.
Yeah. Okay. So good evening. I'll straight go to the topic of OPD to courtroom. Legal challenges doctors face today. Well, medical profession is considered to be one of the most noblest profession. However, it's not immune to negligence due to lack of a reasonable degree of care and skill, which sometimes causes injury or even death of the patient. Unfortunately, the interpretation of the laws related to medical negligence by the different courts and the law enforcing agencies sometimes becomes misleading, and it leads to wrong conviction and sometimes even punishment. So at the outset, let me pay a homage to Dr. Archana Sharma, who left for a heavenly abode on the 29th of March, 2022. I think most of you may be knowing anyway. For those who don't know who Dr. Archana Sharma is, she was a gynecologist who was working in Rajasthan. Actually, she was a brilliant student. She was a gold medalist during her student career, and she was a STEM professor in the medical college. She left that job and joined her husband, who had his own nursing home in Rajasthan. Unfortunately, following normal delivery, the patient went into PPH and finally died. So, following this maternal death, as usual, the local people, the politicians got into the act, and the DYSP informed the doctor that he would be arresting her on a criminal negligence, Article IPC 304A. On hearing this, she went and committed suicide. And her parting words were, "Perhaps my death might prove my innocence." Unfortunately, let me tell you, my dear friend, she could have proved her innocence even without, taking up such a drastic step. Dr. Archana Sharma committed she committed suicide only because she were not aware of the various rules that govern our profession, the privileges that doctors have. It's not like any other criminal. They say that someone dies, you are at once charged of criminal negligence. It's not that. She was not aware, and that is why, and she did this. And in fact, many doctors are not aware of the various laws that govern their profession. On the other hand, patients have become more demanding and they feel that they are entitled to good standards of medical care. And they have, in fact, a lot of knowledge about medical legal issues. And, they have started going on a legal shopping. And you might be surprised to know that there are several avenues available for the aggrieved patients to sue the doctors. You have the criminal court, you have the civil court, you have the consumer court, you have the medical council, human rights commission, women's commission, lok adalat, child rights commission. There are so many avenues for them to go and do it. But unfortunately, doctors think of law only when they have to defend a case of medical negligence. See, I have gone at the length and breadth of the state and even in the country talking about medical, but the attendance in such meetings are very low. And in fact, the organizers put it in the last, when everyone is leaving, on medical negligence or on the laws that govern your practice is usually not given much importance. So that is because they don't think that they should know about the law. Actually, everyone should know something about the laws that govern. It doesn't mean that you should be a lawyer, because it is neither desirable nor is it possible. But you have to know something which and you have to modify your work accordingly, laying stress on communication, documentation, consent, and value based scientific practice. Well, uh, I sincerely hope that every doctor is aware of this landmark judgment. Jacob Matthews versus the state of Punjab, which was delivered on the 5th of January 2005 by the Supreme Court, and this verdict was delivered by the then Chief Justice of the Supreme Court, Justice R.C. Lahoti, Justice G.P. Mathur, and Justice P.K. Balasubramanian. They were of the view that there is an increase in the number of criminal cases their doctors being prosecuted for criminal negligence following private complaints. They opined that neither the investigating officer nor the complainant had the requisite knowledge in medical science to decide whether any unfortunate or mishap occurs, whether it is criminal in nature or not, and whether it has to be charged under 304A. They were also of the opinion that once a criminal case is taken against a doctor, he faces a lot of embarrassment, at the same time a lot of harassment. It's okay. And he has to seek bail to escape arrest, which he may or may not get. At the end of the whole thing, he may be exonerated or even acquitted of all charges. But the loss which he has suffered in his reputation can neither be compensated by any standards. The Supreme Court thus exhorted the government of India and the state governments to frame certain guidelines in consultation with the Medical Council of India to prevent frivolous cases against doctors. They said that till the government frames these guidelines, they put up some certain guidelines. According to these guidelines, to prosecute a medical professional of criminal negligence, it must be the accused should have done something which a doctor in his ordinary sense of prudence would not have done, or he failed to do something which a doctor in his ordinary sense would have not failed to do. So he should have done something which is gross negligence, or he failed to do something which can be considered as gross negligence. Only then it can be considered as a criminal offense. One. Number two, if a private complaint has to be entertained, the complainant has to produce prima facie evidence before the court in the form of a credible opinion from another competent doctor. It's just that the complainant cannot give a case. Third, they said that the investigating officer, before proceeding against the doctor of negligence or rashness, you should get an independent and competent medical opinion, preferably from a doctor in the government service, qualified in that branch of the medical science. And finally, there's the fourth protection was that even if all this is falling in line, he should not be arrested in a routine manner unless the investigative officer feels that his arrest is necessary for furthering the investigation or for collecting evidences, or unless the investigation officer feels that the doctor would not make himself available to face the prosecution. So this is what it was said. And I have gone to many states, and you will not believe that none of these states have any of these, till date have not formed. 2005 this was released, and it has not till date been, no state has formed as far as I know. Only the state which has formed a certain guidelines is the state of Kerala. Today, in Kerala, if a case of criminal negligence has to be charged against a doctor, it has to go through committees. You have a district expert panel and an apex panel. A district panel, when a complaint comes, the DYSP has to contact the DMO, who will form a committee, and that committee will contain the DMO will be the convener. He'll have a district governor, the public prosecutor will be there, a senior government in the concerned medical specialty will be there, and a forensic expert. So so this is the committee that should form. And the forensic expert, you can from the government, but they have specified each district will be, having from a particular medical college. And these these committee members would go through the case sheet and decide whether prima facie there is a negligence or not. So there can be three results that can come out. All the panel all the committee members will unanimously say, yes, the doctor is negligent. Two, they can say that unanimously say that there is no negligence. Third option is there will be a difference of opinion among these committee members. Now, if they say that there is negligence, then the doctor has a right to appeal to the apex committee. Now, if they unanimously say that there is no negligence, the investigating officer has the right to go and appeal to the apex committee. Now, if there is a difference of opinion among the four of them, even if one member has a dissent, puts in a dissent note, then again the investigating officer has to go to the apex committee. The apex committee consists of again the apex body consists, the DHS is the convener. You have a DME in that. You have the additional director of health service vigilance and the director general of prosecution. These are the four people who are there. Again, they can utilize the services of experts from to look into the matter. Here again, they will look through the case sheet. They can call their concerned doctor and then decide whether there is negligence or not. So this is how only then can a case be taken of criminal negligence. Then it goes to the court and then it has to be decided by the court. But this is the process until now. Recently, just 2-3 days back, the High Court has again said that there should be there is proper guidelines. It is not proper. There is a lot of problems with the way the DMO selects people, and so it's still not 100% foolproof. So the High Court has said that you has formed has appointed an amicus curiae to look into that, and IMA is definitely going to give its remarks on this, how to make it more doctor friendly. Now, this expert panel has to give within 60 to 90 days. It should be given. Okay. Now, I think Dr. Arun had told me last time. I said yes, we will be talking about the expert panel. See, expert opinion. There are people who what is the importance of expert opinion? We should remember the expert opinion. It is the it is their basic duty is to inform and guide the panel to come to a correct conclusion. Number one. And expert witnesses, whether the panel can assess the weight and usefulness of such evidence to reach its own conclusion, and the responsibilities of the expert witness. See, expert witness is very important. There are two places they can. One is, as I said, the district committee and the apex committee. Number two is in the courts when they are asked to come as expert witnesses. I have a request to these expert witnesses. Number one is never refuse to come. Please. See, it is one way that you can help your colleague. I always say that it is true that you may have to forego your 1 day's practice, but even then, it's a request that this is something you can do to help a colleague. You should not refuse to come. And number two is there are different protocols I've written. See, there will be when you manage a particular disease or a particular ailment, there may be 3 protocols: A protocol, B protocol, C protocol. Maybe the expert witness is using the B protocol. He doesn't use the A or the C. He feels it is not proper. So that doesn't mean that the A and C is wrong. Suppose the accused doctor has used the A protocol, he should not stand in the court and say that the A protocol is wrong just because he is not using it. If in the standard books it is written that A protocol can be used, he should say that the A protocol, B protocol, there is C protocol. I use B protocol, but what the accused doctor has used A protocol is not wrong. But sometimes what happens is the expert witness comes and says A protocol is wrong. He shouldn't have used it. So that is unfortunate. The expert witnesses should be careful in the court of law. And indifferent attitude. See, sometimes they just another indifferent attitude is one. There was one expert witness. He was in the UK for some time. He claims himself to be a cardiothoracic surgeon, and he claims that he has done more than 100 hysterectomies. That is what he said in the court. This has happened. And he said that when you do a hysterectomy, you should have a cardiologist, a neurologist, and a cardiothoracic surgeon. Only then that institution should be allowed to do. And the court said that, see, it is not we who are saying, it is you people, your own person is telling this. So this such indifferent attitude you should not have. Another thing is we should think of the time, see, and the place where the thing has happened. Usually what you should remember, expert witnesses should remember, is that when it comes to the court, it may be after several years after the incident has occurred. And science and technology, medical science and technology is advancing at a very rapid pace. And, suppose, for instance, I come from a small town like Talisheri. Maybe 10 years back, we didn't have MRIs here. But it was there in Calicut. If an expert witness from Calicut comes to Talisheri court and says that he should have done an MRI immediately, it's not possible. He should understand that Talisheri is a small town, doesn't have MRI. So he should not say, no, MRI should have been done. That case should not have been taken up if the MRI was not done. So such things we should be very careful when you, as expert witness. And you should know what is the difference between criminal negligence and civil negligence. This is very important. As I said, in the district panel and in the state panel, this is one thing that is troubling the doctors. That is, very often when there is a non-complication is never a negligence, but very often the expert panel, some of them says that yes, there is negligence. Merely saying negligence is not enough. You should say whether it is criminal negligence or civil negligence. See, criminal negligence is if a doctor has done something which a doctor in his ordinary sense would not have done, or a doctor failed to do something which an ordinary doctor would not have failed. So this is very important. This is a basic thing. Very often the expert witness, they don't understand that, and they say that there is negligence. They don't say even that it is criminal negligence or civil negligence. So you have to specify whether it is criminal negligence or civil negligence. Acts leading to criminal offense. You see, this is something, the PCPNDT Act. See, PCPNDT Act it is all those who are using ultrasound machines should be knowing the basic concept of what is a PCPNDT Act. Everyone should know that. Those who are using USD should know. Even cardiologists who are using echo, because it is a form of USD machine, they should be knowing what is the PCPNDT Act. Very often doctors are not aware. And the sad part of PCPNDT Act, it is not only revealing the sex of the baby that is considered as a criminal offense, even the records are not proper. Documentation is not proper. It is considered as criminal offense. So all of us, those who are using, and it is now being used point of care ultrasonography, POCUS, which is being used rampantly by a lot of, it's not only by radiologists, not only by gynecologists, it is used by orthopedists, it's used by anesthetists, it's used in the emergency medicine, it's used by pulmonologists, it's used by so many people. And that they should be knowing the rules, because you could be charged of criminal offense. And the other one is the POXO Act. See, POXO Act is something which every medical graduate should be knowing, because there is every chance that a child which is below 18 years who has undergone a sexual assault can come to you, and if you don't report it immediately to the child line or to the local police, you could be charged of criminal offense. Very often, sometimes when you reveal to a mother that your daughter is pregnant, they just catch hold of the doctor's leg and say, "Doctor, പറയാറത് പറഞ്ഞു കഴിഞ്ഞാൽ ഞാനും എൻ്റെ കുടുംബവും ആത്മഹത്യ ചെയ്യും." They fall for it. They don't say, okay, they say, okay, they pity them, they help them, okay, to get it aborted. But later it comes out that this girl was below 18 when she was pregnant. This doctor is going to have it. He or she would get into problems. There could be charge of criminal negligence. So I always tell, especially the radiologists, they are, and the gynecologists or obstetrician. Nowadays, they also do ultrasound. When they do an ultrasound, they find the girl is pregnant. They do a UPT, and then to confirm, they say that, okay, she's pregnant, and they don't reveal it, they are going to have problems. So this POXO Act, as I said, it can come to any, to a doctor who is in the casualty medical officer, who is just, passed his MBBS. He should know what is POXO Act and what are the problems with the POXO Act. And MTP Act also, they should be knowing. See, these are some of the, acts which leads to criminal offenses, which the doctors who are dealing with that, situations should be aware of. I'm not going into this, the POXO Act, as I said. But then, behind every problem, there is a solution. And when I say there is a solution, what I may first and foremost thing is, do not panic. This is most important. Whenever you get into trouble, do not panic. Because when you panic, your thoughts go astray. And when thoughts go astray, the problem swallows you. But if your thoughts are organized, definitely you can swallow the problem. That is what I wanted to say. And how do you organize yourself? How do you organize oneself? The most important thing is documentation. See, documentation, when I can give one lecture only on documentation. I always tell people, document. Keep writing your case sheets. The more you write, the better you write. I tell youngsters, just like the youngsters, they try to get more, and during the training period, they try to do as many surgeries as possible. Physicians try to see as many cases as possible. Similarly, they should be competing among themselves to write as many case sheets as possible, because it is in the medical college that you actually learn how to document. And documentation is why so important, because let me tell you, friends, today, if an unfortunate incident occurs on the 20th of June 2025, probably the case would come up 1 year or 2 years later in the court. You may have done everything under the sun for the patient, but if it's not documented, when it comes to the court, the document says that you have not done anything. What is written in the document is only what you have done. You cannot, there is no point in telling that I had done everything for, but if it's not documented, it's of no use. On the other hand, I would also say that even if you have documented, it is more important. So you may not have done something, but you have documented it properly. That is enough, because that is what the court sees. The judicial officer sees that is the evidence. So documentation is very, very important. Suppose there is an unfortunate death in the OT, you are somewhere, or unexpected death. You bring in your colleagues before you write your case sheet, because, as I said, you will be disturbed, and, your mind will not work properly. And there may be some doctors among you who has a legal brain, who will tell you, do this, do that, write this, don't forget that, all these things. And and I always say that the doctor's records, doctor's orders, and the nurse's record should be matching, especially the time. Sometimes in the OT, the nurse will be writing down at the time at which the medicines have been administered. But the doctor who finishes the case then comes and then looks at his watch and then starts writing, and the timing will be different. Like the nurse has administered the drug much before the doctor has returned. The advocate goes and says in the court, this has happened. That is why I'm saying, says that this is fabricated, because the nurse has administered these drugs were not administered. You can't say no. So you have to be very careful when you write. You should see that the nurse's records and the doctor's orders are matching. Another thing is communication skill. I think I don't have to tell you, breaking bad news is something which everyone should be knowing. Unfortunately, our medical schools have no formal training in teaching people how to break bad news. I have gone around the country speaking on breaking bad news, and I'm telling you, 99% of the doctors do not know what is Spike's protocol. I think it's unfortunate, because such an important part of our practice, but still we do not know. I have written death declaration to be properly timed. Death declaration to be properly timed in the sense that, there is very, very often what happens is the patient sometimes, tells the relatives are informed that the patient is dead, no more. They at once inform the police. The police comes rushing and, seizes. Please mute, mute. Takes away the case sheet. The police takes just like our answer papers are taken away by the invigilator. It takes away the case sheet. I had asked, so when it comes to the court, it sees that you have not. Sometimes we will be busy trying to save the patient. By the time we write, it will be taken away. So in that case, what happens? Because the police says that you are fabricating, you are writing now after the patient is dead. But how much ever we say, they don't agree. So I had asked when I had a discussion, I asked one of the judges of the High Court, Kerala High Court. I asked the person, what do you do? So he told me, I'll tell you what you should do. You should at once inform the SHO. You should inform the DG, the SP, the IG, the DGP, the Home Minister, the Home Secretary, and the Chief Minister that such a thing happened. I was writing the case sheet, because that is evidence. That is evidence to show in the court, that the court will consider, yes, there is some truth in what he says. So I think this is something but the best thing is not to inform till you write the case sheet. Death should be declared only after you are 100% sure that your case sheet is proper. And as I said, the case sheet, it should be, consent should be there, vernacular, note all details, as I said, doctor's orders and nurses' records, time to be properly, The patient's right should maintain record for a minimum of 3 years. This is some question that I always get. People keep asking me, how long should we keep these records? As per the MCI guidelines and the NMC guidelines, we are supposed to keep it for 3 years. But I say always keep it for 5 years, because I'll tell you why I say 5 years, but best is to keep it for 5 years. But if there is some case, some incident which is you're having a medical legal problem, then keep the case sheet till the case is disposed. Don't do it. Keep it in safe custody. Why I say safe custody? It's because there is every chance that it could be, someone could, remove some tamper that case sheet. Someone in your own hospital can do it. So be careful, and supply copy of medical records within 72 hours. I have written. So there are some. This is another question which I get from a lot of people. Phone calls getting. People ask that see, the case sheet is our property. Now the patient's relatives are asking for a copy of the case sheet. You have to give. If they are request, you have to give. You are bound to give a copy. Don't give the original. Even if the police comes, you are bound to give the copy of the case. You are bound to give the case sheet. And that is, but when you give it, first you have to get a written request. Even if it is a police, you have to get a written request asking for the case sheet. Number two, you have to get a receipt from them that they have received the copy of the case sheet of so and so patient, and you should mention the number of pages in the case sheet. It is very important, because they can tamper and say that that sheet has been added. So these are things which we should be very careful, and which every doctor should know. And consent, I think it is another topic which you can speak for a whole day. I'm not going into the depth of it, but just there is implied consent. That is, when a patient comes to your consultation room, it is implied that you don't have to take consent for that. That is express consent. It can be oral or written. Written is for all those invasive procedures, anesthesia, all these things. And it is best that it is obtained in an own handwriting. It should be sometimes, most hospitals have a printed consent form. In that case, you have a lot of Anya Samsthana Tolilaliyar here. You have people who are not very, conversant with the English. And or sometimes it is in your vernacular language, the consent form. So whatever it is always best to write at the bottom of it, I have read and understood and I agree with it, in their own handwriting. Now, this is another thing which I want to tell you. This recently, a case had come up of this such an issue. See, it was a case of abruptia placenta, and the patient, the doctor says that patient died, maternal death. The doctor says that I have explained everything to the patient and the relatives, but the husband says and the local politician says that you haven't seen. When we took up the case sheet, it was just mentioned LSCS under SA. So that case sheet that is the problem. The consent, it should be, if that consent, if it was written a case of abruptia placenta, all the things, one or two known complications of this could have been written in that consent form. It was not written. This is because usually the doctors are not taking the consent form. It is the nurses who take the consent form. Consent. I think that, at least in such cases of abruptia placenta and all those cases, or there's some high risk cases, the doctor himself or herself should take this, should ensure that the case proper consent is taken. And suppose sometimes the patient refuses for a particular form of treatment. In that, you should get a written refusal. Sometimes even they will not give that refusal consent also. That's called the negative consent. That's what we say is the negative consent. They were not willing to give that. In that case, two non-relative, or one of them is a relative who a witness is there, you can ask them to give a consent. Someone who is there at that moment of time can say that, yes, I was there, and they refused to take the treatment. This is one thing you can do. So, however, there are some areas where a consent is not required. One is in medical emergency. Suppose an accident case and a tracheostomy has to be done. Some unknown person has brought the accident victim. You can do a tracheostomy without any consent. The new admission to prisons, food handlers and dairymen, immigrants, members of the armed forces under court order, request of police. Now, this is another important thing which doctors find problem is the postmortem. See, postmortem is something you should insist. When there is an unnatural death or a death where you can't explain the cause of death, then you should insist for a postmortem. Sometimes they refuse. That is, again, you should use for a negative consent. Then request a copy from the policeman and request. Sometimes there is a request. Like I am involved with IMA. I get a lot of calls from my relatives and friends saying that ശ്രീമാറെ നീ ഒന്ന് ആ ഡോക്ടറോട് ഒന്ന് പറയണം ഒരു ഈ ഡോക്ടർ പറയുന്ന പോസ്റ്റ്മോർട്ടം ചെയ്യണം നിനക്ക് പരിചയം ഉണ്ടാവുമല്ലോ നീ ഒന്ന് അവരോട് പറയണം ഈ പോസ്റ്റ്മോർട്ടം വേണ്ട ഒഴിവാക്കി തരണം എന്ന്. See, I tell them it is doctor's job is to just inform the police. It is the policeman to decide whether there is a postmortem has to be done or not. It is not the doctor. But the policeman is very smart. He says, he tells his relatives, എനിക്ക് പ്രശ്നമൊന്നുമില്ല ഡോക്ടർ പറഞ്ഞിട്ടാണ് ഞാൻ ഇവിടെ വന്നിട്ടില്ല ഡോക്ടർ പറയുന്ന പോസ്റ്റ്മോർട്ടം വേണ്ടെന്നുണ്ടെങ്കിൽ നമുക്ക് ഒഴിവാക്കാം. That is what he does. I said that is wrong. That it is only the policeman who can refuse. It is not the doctor cannot do anything about it. So this is something which many people should be knowing. And suppose there is a police inquiry, there is some untoward incident, some death or something, some complication, and there is a police inquiry going on. I always request you to cooperate. There has been, I know instances where doctors just refuse to go. Their ego doesn't allow them to go to the police station. They feel that the policeman has to come to them, has to come to their hospital and inquire. I think that is wrong. They are just, see, suppose I beat one person, that fellow has given a complaint. It is but natural that the police will come to me and ask. Police will ask me to come to the police station. They just want to inquire. So they are coming for an end. They are asking you to come to the police station for inquiry. You should go. You should cooperate. Forgo all ego. Take a colleague along, because doctors generally are not used to all this. But whereas government doctors, I must say, they are used to it. They are more, they are more courageous to go to a police station and talk. But it's not like with the private sector doctors. I think always take a colleague along. Before you go, you discuss with your staff and other doctors who are involved in that particular case, because they might call the other doctors or the staff later. And you should all be telling the same thing. You should not be telling different things. And read before signing. So sometimes what happens when you go to the police station, the police will take note of everything, and then one police constable will be writing the whole thing. If they don't ask you to sign, it's okay. If they ask you to sign, go through it. Don't say that my OP is there in another 15 minutes, I have to reach my OP. No, read it. And if there is something which is written, what you have not said, you should insist that, no, this is not what I said. I said this, you have to correct, otherwise I will not sign. You can tell boldly, nothing is going to happen. If you have to sign, you have to ensure that whatever you have said is written in that statement. And state is the prosecutor. Suppose there is a death and a case is going on against you. Sometimes what happens, the doctor and that the patient's family members, they have an understanding, they have an under the table settlement, everything is done, and they forget everything. But as far as the police is concerned, the police case is continuing. And suddenly you will find that you are having the case against, there is a criminal case against you, continuing. You have already made a settlement. That's not no use, because the state is the prosecutor there. You have to finish the case in the court. That complaint has to be withdrawn by the patient, relatives. Now, coming to the, we have finished the consumer courts. I think you should just have little knowledge about the consumer courts. I'll not go into depth of it. There are three areas. There's a district commission, there's a state commission, there's a national commission. That is, at the district level, there's a court, at the state level, there's a court, and the national level. Then directly to the Supreme Court. There is no high court as far as consumer courts are concerned. Very often people think that there is also high court. No, district, state, national, and Supreme Court. That's all. And at the district court, up to 1 crore you can ask for compensation. State commission, it could up to more than 1 crore, up to 10 crores, and the national above 10 crores. Just imagine. And initially, before 2019, there has been a new Consumer Act come out. Before that, the complainant should be either in this place, can give a complaint in the same district where he was working, where he took the treatment, or where the doctor is residing. That is the only place where he can give. Now, what has happened? In 2019, that the new act says that fellow can give a complaint in his own area where he stays, where he resides. So as long as he's in Kerala, it's okay. Suppose an Anya Samsthana Tolyali from Assam comes here and he treats a treatment at Ernakulam and goes to Assam, Dibrugarh, and then gives a case there. It is the doctor's responsibility to go to the see. It's very unsafe for a doctor to go there. And imagine the trouble he has to take. He has to find an advocate for that. So this is a big problem as far as doctors are concerned. And as I said, you can give a case within 2 years as far as consumer courts are concerned, and civil courts, you can give a case within 3 years. This is the time. If there is sometimes the court may condone the delay further. So in a civil case, if it is more than 3 years, if it is 3.5 years, they can sometimes say that, suppose there is a case of amputation and that fellow says that I was busy going for my artificial limb treatment and all that, I couldn't file a case. Sometimes the court may condone that delay of 6 months. So, and you have destroyed the case sheet, then there is no evidence. That is your biggest evidence. So you should always keep, I always say, keep it for 5 years. And it is the responsibility of the complainant to prove the allegation. This is very important. But there is something called the res ipsa loquitur. That is, the incident is so obvious that here the complainant doesn't have to prove. We have to prove that we are not negligent, because it speaks for itself. For example, when I give the example, you will understand. One is amputation of the wrong limb. There's nothing you can say. It's proof that you are negligent. Removal of the wrong organ. In one of the hospitals, I'm not mentioning the hospital, 2 patients of the same name came. One came for circumcision, other came for tonsillectomy. 2 boys, the same name. And unfortunately, the ENT surgeon did tonsillectomy for the circumcision patient. And when the surgeon came, he realized that this is the wrong patient. So this happens. Operation on the wrong side. Don't think it is very uncommon. It doesn't happen. Even in US, you all must be knowing, Sri Devi's mother got operated on the wrong side of her brain in the US. Imagine. And leaving a mop or instrument inside. These are all some of the common examples which I have to give you. That is called the res ipsa loquitur. Vicarious liability means, suppose you are working in an institution, the institution management is also vicariously responsible. This is what. Here, I would add one more sentence for those who are medical college teachers. Let me tell you, the PG student, when the PGs are working under you, you make under vicarious responsibility, but still they are independent. Whereas the house surgeons may not be charged of any negligence. It will be the head of the department, head of the unit, or the head of the department who would be vicariously responsible for any act of negligence on the part of the house surgeon, because they have only temporary registration. And medical councils, I'm not going into it. Only this much I'll tell you. Gives and as for the you may be thinking why I'm talking about MCI. It is not NMC. Actually, NMC had taken out its guidelines, but it was withdrawn 23 days after it was, and it's still not come out again. So till then, the MCI guidelines are going on. You should not be taking gifts. Let me skip this. I think lackage of. Okay. Lok Adalat. This is another area where a complaint can be given. Lok Adalat is a case where, it's a court. It's a sort of court which is it is presided by a retired judicial officer who is the chairman, and 2 other members, usually a lawyer and a social worker. There is no court fee. And, that is usually, the compromising. You come to an agreement. You just sit down across the table, discuss, and try to finish it off. Those cases which have not gone to the court can be taken. Even those cases which have been taken up in the court can go to the Lok Adalat, and you just have a settlement, a sort of settlement. You sit across the table and discuss, and finally, okay, fine. Then that case can be withdrawn from the courts, even if it is. So this is another area where the patient can go and give his her complaint. And there is Human Rights Commission, Women's Rights Commission, Child Rights Commission. Very often this Human Rights Commission, the patient goes and gives a complaint to relatives, go and give a complaint to the Human Rights Commission. The Human Rights will take out one, a statement against the doctor or the hospital, and even award a punishment of 5 lakhs or 10 lakhs. But that is absurd. The Human Rights Commission has no right. It can give a statement. They're saying that, saying that deploring the acts of the doctor and saying that there's human rights violation, all that they can say, but they have no right to award any sort of compensation to the people, to the patient or the relatives. You can go to the High Court and squash it. Even the same thing, same as with the Women's Commission, Child Rights Commission. That's why I put all three of them. I think this is all that you have to know. You don't have to go in depth of knowing everything. And I always request you to keep yourself safe, update or outdate. That is what if you don't update, you will become outdated. And you should have 30 hours of training every, a CME every 5 hours. This is what it is said. And you have to keep upgrading your skills. Then this is another important aspect which you should know. See, sometimes what happens is, suppose an untoward incident has occurred, and there'll be a lot of pressure on the doctor. പലപ്പോഴും അവരുടെ colleagues-ഉം അവരുടെ family members-ഉം പറയും, you give a press release, or you have a press conference. When it goes to the IMA, they'll say the doctor for a press conference will come, or they'll be in the social media, replying in the social media. My humble request to this is a big no. The concerned doctor should keep his or her mouth shut. It is best that they keep their mouth shut. Because for the reason is, because when see what happens in the press or what happens in the social media or what happens that is immaterial. What happens in the court is very, very important. So if you make a statement you take out a press release, or you have a press conference and that is recorded, or in the social media you have told something, you can't retract from that statement. Sometimes in the court there are some statements you have to retract, or you may have to deviate from the original thing. So it is very difficult. Once you have told it publicly that this has happened, you can't retract a statement. So it is always best not to. Then you will ask what they can't keep continuing to tarnish your image. No. What your IMA branch members, leaders can do it, your hospital authorities can do it, because in the court of law, you can say, it is not my statement. They have misunderstood things and they have told. That is their state, that is their opinion. What actually happened was this, and you can do it. So for heaven's sake, please don't go for a press release. The doctor involved should not go for a press release or a press conference or a social media, replying social medias. And this is one of the most horrendous thing which is happening today is the cyberbullying. It's called the new age Ravana. It's an aggressive intentional act carried out by a group or individual using electronic forms of contact repeatedly and over a time against a victim who cannot easily defend himself or herself. What is the very intention? One is to intend to harm the concerned doctor or the healthcare institution. There is an imbalance of power because you are alone. They have a battery of people, who will be writing, and the public who have nothing to do with this, and they also will be writing. They will vent out all their anger, frustration against the doctor community in that. There will be repetition of the act. Something has happened today. It will that accusation may again come up. You will see that thing, WhatsApp messages circulating, or in the Facebook, it will come up again. Or maybe 1 year later or 6 months later. So it will be repeated. How do you react to it? There are two ways of doing it. One is a non-legal approach. The other one is a legal approach. As far as the non-legal approach is, you ignore it. Sometimes you just ignore it. It has come and there are very often many people come and tell me in the WhatsApp something comes. We have to say something against this. We have to file a case against this fellow. One WhatsApp message comes, don't bother. Or even have numerous messages, just ignore it. If you may respond to it sometimes in the Facebook or in the YouTube, it comes up. You may respond, but don't try to provoke them. Try to get it deleted from the platforms if possible. Suppress it. Suppress it means you take out many other things and suppress that main news. Suppose you are intending, you may have to go for a legal, but one request is, whenever all this, keep a record of all the defaming statements made towards you. Even if you're not going, do it. You don't delete the photos, emails, or any other information sent by the perpetrator. Take screenshots of the posts, comments, search engines, incriminating dots, and print them out and keep it. hold on to the evidence that indicates the user's identity. So these are things which you prepare yourself. You need not go legal, but if at all you feel, you should be ready with it. Otherwise, once these things have gone up, they may have taken out something and then deleted it. Then you can't say that they have put out a post. There's no point in telling that. You should have adequate proof. So do that. And as far as legal approach is concerned, you can file an FIR. There was a section 66A. Thanks to the Supreme Court, they have removed that. It is very unfortunate. It was a very powerful act section, but that has been taken away by the Supreme Court. We have now 69A and 17I of the IT Act. And your legal approaches, one is you can give an advocate notice, or you can give a defamation suit. Defamation suit is very time consuming. It is very expensive. You don't think it is very simple. It's very time consuming and expensive. As I said, you have to collect all these documents. It can, rebound against you. So legal approach, when you go for a legal, Mark Twain had said, a lie can travel halfway around the world while the truth is putting on its shoes. And what you should remember also against the legal approach is the Cobra effect. I don't know how many of you know what is Cobra effect. See, Cobra effect was pre-independence. Then during the British rule, there were a lot of cobras in Delhi. So they took out saying that anyone who brings a dead cobra, kills a cobra and brings he would be adequately awarded. And Indians here, they are very enterprising. What they did was, initially they used to kill cobras and give. Then they started breeding cobras. They started breeding cobras, used to kill them and then go and give it and collect money. Soon the British government understood that this is what is happening. They, one fine morning, they took out another order that thing is over. We are not going to give any more money to these things. What will they do with these cobras? What they have been breeding. They let them onto the streets, and the number of cobras then increased. So what I wanted to say was, trying to bringing out something, trying to solve a problem, made the problem increase the problem. This is sometimes what happens when you go for a legal approach. Because sometimes it would have died down. That incident would have died down. But when you go for a legal approach, each time it comes to the court or somewhere, again it will be raked up. And this is one thing which this will be my last slide before I go. Edward, you can get an advocate notice from patients. In that case, PP scheme will help you. Notice from the court. Again, the PP scheme will help you. But there is something which you should all know regarding how the process is in the court. You have to sign a wakalat. That you have to sign with the advocate. Wakalat means you are appointing that advocate as your to represent you in the court. There is a time for filling up the versions, and then the complainant will be examined by your advocate. After that, the witnesses of the complainant would be examined by their advocate. Then he would be cross-examined by your advocate. Then the evidences of the complainant is closed. Then you come into picture. You will be cross-examined by the complainant's advocate. The witnesses which you bring will be examined by your advocate and cross-examined by their opposite witness. Then they would be posted for argument, and finally it would be posted for order of judgment. What I wanted to say this, why I brought this slide is because what you should all know is this is what happens in the trial court. Suppose you lose a case and then it goes for an appeal. It's the appeal court. When it goes to that is from the district court. If it goes to the state commission, then it is an appeal court. So it is only in the trial court that you have a chance to say everything. Whatever you want to say, it can be told only in the trial court. You are never given a second chance to tell in the appeal court. So don't think that if you're in the first class judicial magistrate, you have a case, and when it goes to the high court, very often doctors, when I ask as a PP scheme secretary and as a PP scheme chairman, now as NPP scheme secretary, I said, why didn't you put this, why didn't you tell like this in the court? No, I couldn't tell you. Don't worry, I will in the next, when we go for appeal, I will tell. No, you are not given a chance to tell in the second time. So you can only tell everything, whatever you want in the trial court. This is very, very, very important. So you should be working in tandem with your advocate. Just because PP scheme is doing everything, don't think that you have no responsibility. You have to sit down with the advocate one day prior to the hearing. You have to follow up the case. You should ask the advocate when is the next sitting. You should see that the advocate is going to the court. It is not the responsibility of the secretary of PP scheme alone to monitor all this. You have a responsibility. That is why I said you should be following up the case and not putting every responsibility on the head of the secretary of PP scheme. To conclude, I must say that let us accept the fact that medical services are being subject to various forms of litigation, but there's nothing to apprehend or fear. Let us treat patients with the respect for their rights, give them accepted evidence-based treatment, standard and compassionate care, maintenance of proper records, and above all, take them in confidence as partners in the care of the health. This is as far as the legal aspect is concerned. I think I will just take 5 minutes to tell about the Doctors Support Committee. See, this is one committee what I had relentlessly in many SWCs, state working committees. I had raised this that we should have some committee to protect support the doctors, because doctors today are facing a lot of problems irrespective of the age which they belong, whether it is not only seniors or juniors, they are having a lot of problems in their workplace. So young doctors, therefore, is a lot of complexities in establishing practices. They have scarcity of job opportunities. They have extended working hours. They have inadequate remuneration, stressful interpersonal dynamics among colleagues. The middle-aged doctors are finding it very difficult to cope with personal and professional challenges. They are retired and the elderly are also, feeling lonely, and, sometimes the spouses are no longer their doctor's wives. Sometimes, they've held a very high esteem. But when the doctor dies, no one is bothered about them. No doctor comes and visits them. No doctor is bothered about what is happening. So these are things which we should do. Even senior doctors are sometimes in the management, tries to push them out, bring out false allegations against them. This has happened. There is a lot of problems with the doctors. So there should be, IMA should be taking the responsibility of solving this. That is why I said we should have a doctor support. And in IMA, there is a problem. Whenever you say something, the responsibility thrust on you. Because I raised this topic, I was made the chairman. Anyway, we have been trying our best. We are having a lot of teething problems with this committee, but still we have building it up slowly. Doctors committee is called the Doctors Support Committee at the state level. There's a doctors support cell in all the 109 branches of Kerala State IMA. It provides a platform for the doctors to address their grievances, and they will help them in challenging, the various challenges. And so at the state level, there is a chairman, there is a vice chairman, there is a convener, and there are 14 district coordinators. 14 of them, all the 14 districts have one coordinators. And in the cell, in the branch, there is a chairman, there is a convener, there will be 5 members. One is the 35-year-old, below 35 years of age, one between 35 and 60 years of age, one above 60 years of age, one female member, one psychiatrist. We have purposefully added this because, see, the young doctor who is below 35, he will not be feeling comfortable to complain again. Suppose his senior doctor is harassing him. Sometimes the medical colleges or in hospitals, they have these problems. So he will not find it comfortable to complain to a 60-year-old. So he will be more comfortable if his own age person is there. So that is why we included. Similar is the case with the above 60-year-old doctors and between 35 and women have their own special problems. So we should have a women representative. That is why women representatives are included, and a psychiatrist. There's a lot of increased suicides and even divorces among doctors nowadays, because of the stress that they undergo. So we should have a psychiatrist. That is why we have them. And they have been, this doctor support will intervene in issues related to the service condition, professional relationships, personal problems, and these committees, there will be branch president, secretaries, ex officio members. The branch, once you have give a complaint, they will take it up, discuss. If they are finding it difficult to handle it, it comes to the state committee. The state committee will they will look into the matter. Right? We have solved. So I was surprised that even today I got a request from one doctor that is, I was not getting my remuneration. I left the hospital. Now they have given a notice, advocate notice against me. What should I do? There are so many people who are having so many problems. You will be surprised. because slowly people are becoming aware of the existence of this doctor support cell. My request to each one of you is to propagate the presence of these things, that there is a support cell in your branch and you can find out who the office bearers are and you can help your colleague in solving out this problem, their problem. So be the ambassadors. Thank you. Stay strong, stay safe.
You, Srikumar, for that very, very, I'll say very thorough talk. And then you've sort of taken us from theory into the actual practice. And I'm so glad you spoke about the doctor support cell. With you in ASHA, I hope we can work with the doctor support cell along with ASHA, that we can take that forward at some point of time. I'm sure there'll be a number of questions. Jimmy and Shija, were you able to look at it,
Yeah,
the
sure.
chat?
Yeah, chat, nothing much has come as far as I don't know whether there is any mic problem or.
No, but perhaps people were not told that they can put their questions in the chat.
Yeah, maybe we can ask them now to just.
Yes.
Yeah,
I think
you
we
can
can.
ask.
Yes.
Whatever I can answer, I'll tell.
Yes, of course.
Yeah, we can unmute and ask also. We have time for some quick questions, I feel.
Yes. So if there's anybody who would like to ask a question, this is the time to do it.
Hello.
Yeah.
Arun, I am Dr. Sadish from Kottayam.
Yes, Sadish.
Yes.
Please.
Thank you, sir, for the excellent presentation. And I am a psychiatrist. I was earlier working in Kottayam Government Medical College. So there was a case in which I was asked to report to the High Court. That letter came from the office of the DGP, Director General of Prosecution, or I am doubtful, was it from a Advocate General also. So that was a case related to habeas corpus court, habeas corpus. Say, a nephew of a patient approached High Court telling that my uncle is missing. Really, that uncle was under the care of 4 daughters. He has got 4 daughters, and he was a case of psychosis. And he was admitted in Kottayam Medical College. Then after 3 days, I got this letter from either from DGP or from the Advocate General to report to the High Court with a statement prepared in the legal document that way, etc. So I reported there. Then the judges told the advocates also, why you summoned that particular doctor? Because this patient is in the government medical college. The government doctor looking after him. He has already submitted the report of that matter to the court. Why you ask the doctor to come to the court? So that was the response. Now I want to know whether a Director General of Prosecution or his assistant or DGP or Advocate General office can summon a doctor like this, or shouldn't it come from a judge?
Pardon?
Judging order varan. Can an Advocate General or his office or his assistants or DGP, Director General of Prosecution, or his assistant can summon a doctor?
No, actually, it is for the court to decide whether
Yeah.
you should be called or not.
Yeah, right. Actually, that judge just called at that particular advocate also, who appeared for the other person. Thank you, sir.
Sir, I hope you can talk a little bit about professional protection scheme and how important it is and what IMA is doing when you have that.
Professional protection scheme is you have any problem associated with your practice, not your personal issues.
Yeah.
Any issue with your saying you have to be a member of it, and once you are a member, that the coverage is for 1 single year, and the coverage, monetary coverage is 10 lakhs for a single case and for a single case, and 20 lakhs for multiple cases in 1 single year. Okay, that is if you have a one basic unit. Now you can take multiple units. Suppose you take 5 units. You have to pay 5 times the premium of a single unit, and then you get the coverage of 5 times. So you get 50 lakhs for a single case and 1 crore for multiple cases in one single year. That is called, you can have multiple units. Then there is something called the enhanced unit. Enhanced unit means first you should have a basic unit. Along with it, if you pay 10,000 extra, then you get a coverage of 1 crore for a single case. That is 1 crore plus the 10 lakhs which you have for the basic. You get 1 crore 10 lakhs for a single case in one year. One very important
Okay,
thing
sir.
which
Plus,
you should all know. Many people, they don't join the scheme. They just don't. Repeatedly, people go and ask them to join. They don't join. When they come to know, they realize that one problem is there, and there is a possibility of some legal issue coming up. They come and try to join the scheme. Let me tell you, you will not get coverage for that. The rule is that when that incident occurred, you should have been a member. Suppose incident, you were a member, you have joined on the 6th of 20th of June 2026. If that occurred, it's okay. If you are joining on 21st and the incident occurred on 20th, you will not get coverage.
and for criminal case also, this
A criminal case also, all cases, whether it is in the criminal case, consumer, civil court, whether it is in a human rights commission, advocate notice, any issue, it will be covered.
There is
Even against violence against doctors, that cases also will be taken up. Even cyberbullying, that also will be taken up.
there are several questions in the chat box, which I think. So one of the questions is, in the case of outpatient follow-ups, we may not have the records with us.
No, you are not supposed to keep the outpatient records. But frankly speaking, NMC's guidelines, they had said that, but we are opposing that because it's not possible to keep we can't have a copy of all the outpatient records. Anyway, that has been withdrawn, and I don't know when it will come again. But MCI guidelines say only about inpatient records.
Yeah, another is that what's the legal status of the discharge against medical advice thing? People request or forcibly want to go and all that. This thing. It's a good.
That you have
question.
to mention in the case sheet, and they have to sign also. That is the best thing. Signature is very important. Get it signed, and always have a witness along with it. That is very important. See, even when I always tell even the radiologists, all for that matter, anything. Suppose, what happens is you take a CT scan and the patient goes off. Then someone else comes and takes that report and goes. He doesn't give it immediately to the patient. The patient then goes to some other hospital, and that time you will not, and they blame this hospital for not giving the report. But actually, if that has been signed, and that fellow will refuse, they will say, no, we have not collected. But if while collecting, if you ask that fellow who is collecting to sign in somewhere with his phone number, you can easily show them that this has happened many a times. You show them that yes, this so and so person has collected. So these are everything. Documentation is very important. You have to use a legal brain. You can't tell everything. You should use your brains to document. What are the possible complications you have to think of and do?
Sir, in such instances, who should be the witness? It should be somebody who should be the witness in such cases. So you told that you have to get a witness.
No,
when they sign
someone who is
working in the hospital or
no,
somebody.
Not in the hospital, not your hospital, someone outside the hospital, because the hospital that is not correct.
Yeah.
Someone who is not related with the hospital.
So it can be a patient's.
Yeah, can be a patient's relatives also.
Okay. Thank you,
Dr. Vasudevan, Srikumar.
Sir.
I'm Dr. Sukumaran from Kottayam.
Oh, sir, how are you?
So if somebody leaves against medical advice, it is said that you should not write because of financial constraints. Is it true?
That I'm not sure, sir. That I'm
because
not
somebody
sure.
wrote discharge against medical advice due to financial constraints. Somebody said it should not be written because you are bound to give treatment even if the patient does not have money, is it?
No, actually, that is what they say, that, when it goes to the court, they will say that you should have given the treatment. When you should not take, finance should not should not come into consider. Suppose a accident victim comes, some accident happens and the patient is brought in, and you say that you say that there are some hospitals who say that you pay the amount and then we will do. No, that
Okay.
is not to be done. That is not entertained. You have to save the life of the patient. Money you can recover later. That is what they say.
Okay.
There is a question about the MLC aspect in a burns death. What should a doctor do when, in spite of sending an MLC report and requesting for a medical legal postmortem of a burns case to the concerned police station, if the police officer has handed over the dead body directly to the relatives without the postmortem and without duly informing the concerned doctor?
No,
Who
that
has-
it is not the fault of the doctor. It is the doctor's duty ends with the minute he has referred the case to the police officer. It is the responsibility of the police officer to ensure that it is done or not. He should say that I do not know the cause of death, and I recommend postmortem if he writes. Then his problem is over.
Right.
I think there was a question about the doctor support cell, and this is from Dr. Christina George. Can the doctor support cell reach out to doctors going through an obvious professional crisis? So instead of if the doctor does not approach the cell, can the members of the cell, if they know, reach out to the doctor? Is there a provision?
Pardon, no, I didn't get that point. I didn't get your question.
Shriman, usually if a doctor is in distress,
Yeah,
or has a problem, they will come and approach the IMA doctor support cell.
yeah.
Suppose they do not do that. Can
Oh.
a colleague of theirs come to the doctor support cell, and can the cell reach out to the doctor?
No. Someone has to come and tell us. Otherwise, how will we know? That is the important thing. Suppose some colleague comes and says, "See, this doctor is in distress. You help." Definitely, we will go and approach. I'll tell you one lady doctor. She's doing a post graduation, not in Kerala. She's doing in another state, and she had some problems with the teachers, like the associate professor and assistant professor. One of the associate professor was harassing. That is what she was telling. There was another assistant professor who was supporting her, and we came to know about it, and she wanted some sort of like help from us. She wanted counseling. And the best thing was her husband is a psychiatrist who has just passed out. And she says, I don't want his counseling. I would like to have someone else. Then we arranged a top psychiatrist from Kerala for her. And the psychiatrist was very kind of, he accepted our request, and he started counseling her because she was scared that she didn't want to go further, because she was scared that she would be harassed during exams, because finally the professor teachers would be deciding things. So she said, don't go beyond that thing. I want counsel. I am totally depressed. She came forward. We got this news from someone else. Then we approached her and then helped her out.
Sir, another query from Dr. Sibin about residents. In medical colleges, I think you already answered it. Are residents or the PGs responsible for surgical cases done by them, or the responsibility goes to the unit chief?
No. So they're resident doctors, because they have a permanent registration. Once you have a permanent registration, that happens. See, I don't want to name a thing. There was one incident where, res ipsa loquitur. That, obvious. The case was so obvious. And the surgery was a very long surgery. It took hours together. And, people start changing. Like one group comes, the other group comes. So somehow one instrument was left in the abdomen, and a case was registered. So the PGs, there was an out of court settlement in that case. They collected money and gave it, but as I said, they didn't, because the PGs refused to help refused to refund that money to the professor. The case, he didn't withdraw the case from the court. And what happened? The case continued, and a verdict came of, you have to pay. And all these fellows, these PGs had passed, and they were working in different hospitals, in private and in government hospitals, and they were all booked for that. Because this is what happens. They should have just given that money and finished it off, or the professor should have said, okay, fine, you're all my students. Okay, I'll pay for you. Nothing happened, and this is what happened.
There's another question about outpatient records. You've answered it before, Srikumar, but perhaps you can reassure this person. If a patient sues based upon outpatient treatment and that the medicine prescribed was not following guidelines, we do not have any proof in such situations. What should we do?
No. See, they have to. It is. As I said, I had told this in my talk also. It is their responsibility to prove that you are at fault, except in cases of res ipsa loquitur. So in that case, they have to provide all the the outpatient records. In the outpatient records, you have certain things to say. Suppose you have done what are investigations you have recommended. Suppose the drugs which you have written, certain findings you will be writing there. You may have advised a CT scan, but they haven't done a CT scan. If it is written advised CT scan there, and they have not done a CT scan, it's not your fault. It's not your fault. And later they find that she had a tumor or he had a brain tumor. The patient comes for a headache and repeatedly came to you, and then you advise CT scan, and the patient didn't do it. They didn't follow your instructions. But later come and say that. But if it was, suppose you had advised and not written it, then you have nothing to defend yourself. So always I said, write in the case sheet, write in your OP ticket also, because they have to bring their OP ticket and to prove that you have not done the necessary.
That's a really good suggestion, Dr. Srikumar, because don't write repeat all is what you're saying. Write the medicines and what you have advised in the OP.
Yeah.
Even if it's a busy OP.
Now, suppose a patient comes with headache and vomiting. You have looked for the neck rigidity, but that time when you looked, there was no neck rigidity. Later, the patient had neck rigidity, had meningitis. You just write neck rigidity, neck minus. Just write. There's no harm in writing that, because otherwise you will say you have checked for it, but that time it was not there. So these are things. Another thing is allergic to some drugs. See, what happens is, suppose a patient came to you, you have seen that you have written amoxicillin. The patient had allergy. Sometimes what the doctors do is, at the top of the prescription, they write allergic to amoxicillin. Actually, you should write it below. The first prescription which you have written, you have write it below and say that allergic to, because when you look at the prescription, it's written at the top, and after that you have written amoxicillin. Or you have to, if you are writing there, write the date on which you have written this. Either of them. Very often, sometimes people do that. They just write allergic to amoxicillin and then continue with their treatment. But actually, the patient was, you have written that allergic to amoxicillin only in the second visit. So that has to be, these are things which are small, but you can lead to a lot of problems.
Sir, one more thing in connection with that. You have prescribed some medicine and the pharmacist has wrongly given some other medicine, and the patient might complain to the drug inspector. Are you liable in any way?
No, you are not liable for it. You are in no way liable for it.
Right.
Well,
But suppose it is from your own, some people dispense medicine. Suppose a doctor is dispensing medicine in his clinic, and it is from your own clinic, then you are responsible. Because very often what we say is that we don't have a pharmacist. It's not an open pharmacy, suppose. What I meant to say, open pharmacy means you have a pharmacist and you have a license, drug license, and then that is an open pharmacy. Suppose you are not having an open pharmacy, you say that because I'm not having a pharmacist, my nurses are doing it because it is under my supervision. That is what we say. In that case, you will be held liable. But in the other case, it has gone to some other pharmacy and they have dispense something else. It's not your problem.
There's one more question there, me and Shrija, about outpatient.
Yes, in medical college, OPD resident may write prescription, sign and write for the professor. If any issues are there, if there are any issues with the prescription, who will be responsible?
No, that the entire team will be responsible. If anything else, the entire team will be responsible. Then you have to prove whether you are willing to go and tell in the court that it is not mine. It is the process that is your headache.
One more is there.
So there's a question from Asha Warrior. Consent form need to be signed by a surgeon too. Needn't be signed by a surgeon too, but I always insist that surgeons should look at the case, at this consent form. It is very important. For heaven's sake, stop writing abbreviation. See, stop writing abbreviation. I have gone and asked nurses. They have written they write like TAH with that with that I and that line above with BSO, with along with PFR under GA. This is the consent form where they write. I have asked, can you tell me what the full form is? They have not been able to tell. It is transabdominal hysterectomy with bilateral salpingooprectomy with pelvic floor repair. This is what it is. And I say that how will the patient know? If you are written the consent form is signed by the patient will say, I don't know all this. They came and told me sign here, I have signed here. So for heaven's sake, don't write that way. You write the full, even in the discharge summary. There are sometimes nowadays you have discharge, especially if there are super specialists. Here's my sincere apologies. You have so many terms. Even people like me, I am an ENT surgeon. I don't recognize so many things of what you say there. We look at the discharge summary. There's so many alphabets are there. Sometimes we don't understand what is written there because you may understand, we won't understand. So nowadays it's all printed things. So at the end of it, if it's possible, just with a click, you can write the full form of those. In the where the diagnosis is there, you may write all this what you want. But at the end of the case sheet, if you could write what is the full form of these abbreviations, it would be a great help to people like us. That I have requested wherever I get a chance. Because when a second doctor looks into it, he not of that specialty or a different specialty, he finds it difficult to understand what has happened. And there are so many new things that happen. I will not be knowing everything about urology or plastic surgery or cardiology or cardiothoracic. So many words that they use. So it's always good to have the full form written at the end of it at least, because you can't write the whole thing in the where the diagnosis is.
I think we're sort of coming to the end of our time today. Thank you so much, Dr. Srikumar. I think you've sort of given very, very practical tips to the group, and perhaps we should come out with something, sort of a short statement. What are the things the doctor must do, and what are the things the doctor must not do? Two sides of an A4, I think, be really helpful for most doctors. But thank you, Dr. Srikumar. Shrija, would you like to?
Yes, sir. So, good evening, everyone. On behalf of Team ASHA, it is my privilege today to propose vote of thanks after today's very thought-provoking session. First and foremost, our heartfelt gratitude to Srikumar Vasudevan sir for his insightful talk on legal challenges that doctors are facing. In today's increasingly litigious medical environment, your words resonated very deeply, sir. And your presentation was both sobering and it was also solution-oriented. So it is an invaluable contribution to our collective knowledge, collective well-being also probably. And I would also like to express my sincere thanks to Arun Kishore sir, who is the brain behind ASHA and who has chaired this session for the gracious facilitation and thoughtful reflections by which he has anchored the discussion today. And a special word of thanks to all the other ASHA members here, Alfred sir, Ashoka ma'am, Jimmy, Smita, and all the others who could not be here today with us. And this talk actually aligns, I think, perfectly with ASHA's mission. It is to reduce the stresses that doctors are facing today. And legal kind of Damocles sword is something which is a major stressor, I think, in today's practice environment. And finally, a warm thank you to the participants, to each and every one of you who have joined here today. especially those who have participated very actively in the question and answers. And your engagement has affirmed the importance of the ASHA platform. So let us carry forward today's insights that we have got, and with an increased sense of awareness and preparedness. And thank you once again, and wishing you all continued peace and strength in your practice. And as Sir has mentioned, IMA it is enlightening and also reassuring to know that IMA is also there with you if you're landing up in problem. So thank you, sir. Thank you once
Thank
again.
you so much.